Okay, I believe we can start. So, good morning, everyone, and welcome to this CPDP session organized by the University of Turin under the title, What is the Public Interest in the EU Digital Rulebook? I'm Ludovica Paseri. I'm a postdoctoral researcher at the University of Turin, at the Law Faculty in Philosophy of Law and Legal Informatics. And today I'm very happy to be here with this wonderful group of speakers. And I'm very happy to have the opportunity to moderate our discussion about public interest. So the intention of our panel is to engage with a very contested, very difficult to deal with concept, which is the concept of public interest. From the GDPR, the General Data Protection Regulation, to the Digital Services Act, but down to the AI Act as well. The European Union is increasingly relying on public interest rationales in order to justify different kind of interventions or to derogate to general rules. So, and that's the concept of public interest is under-researched, even if this concept is highly debated. And it shifts, it depends on different legal traditions. It has different interpretations, changing according to different legal traditions, different policy objective, and also different competing visions of the market of fundamental rights, just to recall the theme of CPDP 2026. So, well, the notion of public interest finds its meaning in contrast to private interest, within what the Italian philosopher of law Norberto Bobbio called the great dichotomy, the major dichotomy between public and private. And this matters for us considering the EU Digital Rulebook for two main reasons, basically. First of all, we have a theoretical problem of framing, because this dichotomy between public and private basically is increasingly blurred in today's digital governance landscape. And this is making difficult to clearly identify what public interest means, the different interpretations and operationalization of the concept. And second, starting with this theoretical problem, we have also a practical implications, different practical implications. So this theoretical ambiguity basically affects how public interest is operationalized to some extent. So think about, for example, the priorities at regulatory level, or think about the achievement of public interest values delegated to private actors, for example. So the goal of our panel is to discuss, first of all, the notion of public interest, the different interpretations of public interest, but also to look at the practical implications of these different interpretations. Of course, this is a very difficult task. This is a very broad and complex undertaking for us. So methodologically, let's say we will develop our discussion in four steps. We'll start looking at the public interest from a public perspective, from the perspective of public actors. Then we will move on looking at the public interest from the private angle, considering the market perspective and the relation with the achievement of public interest from private actors. And then we will consider the implementation of public interest purposes according to the DSA. And finally, later, we'll consider looking forward the possible developments of the EU Digital Rulebook, considering the role of omnibus packages for the public sphere. So let's start with Sofia Renshordas. Sofia is a full professor of administrative law at the Tilburg Law School. Her research focuses on how digital technologies can exacerbate or generate new forms of vulnerability in citizen-government interactions. And she's also focusing on possible strategies in order to empower the individuals involved in this dynamic. So in light of your work on vulnerability, I was wondering, I'd like to have your opinion about the notion of public interest operating in practice within the EU Digital Rulebook, in particular considering the risk related to possible reproducibility, let's say, of asymmetries, power asymmetries, and the risk to increase vulnerabilities. The floor is yours.
Thank you.
Yeah.
Well, thank you much, Lodovica. Thank you for being here. And I would like to start where I always start with my students in administrative law, because I'm a professor of administrative law. Nobody likes it. It's like, the least favorite course when you study law, I guess. But when we talk about public interest, we have to actually focus on administrative law. And basically, when I teach on public interest, I basically always say, well, it's not about how public interest used to be like in the 19th century when administrative law was created, but actually how it has changed and how it's changing right now with the digitalization of public services and the automation of administrative decision-making. And I start with this public law idea of public interest because basically, when we actually start learning about administrative law, we actually learn that the public administration only exists to pursue and protect the public interest. And the European laws on the digital, like the GDPR, DSA, the Data Act, the AI Act, they all refer to the pursuit of the public interest. They refer to it in different dispositions. And yet, the puzzle that I would like to share with you today is basically that the public interest in all these laws is always assumed, but it's rarely defined and almost never examined and gets the concrete government interactions that we actually experience in our lives. So basically, with the digital, we see that the whole interactions between citizens and government has changed. The GDPR, the DSA, all these acts try to regulate fragments of this interaction, but they don't actually address the real change in the public interest pursuits. And furthermore, this pursuit of the public interest, on the one hand, the pursuit that is actually mentioned in all these acts, it does not take into account the structural or relation vulnerabilities that we encounter when we actually interact with digital governments. And on the other hand, this pursuit of the public interest in abstract does not actually account for the fact that actually it is a pursuit that also creates new epistemic and procedural vulnerabilities. So the law is also creating new vulnerabilities by itself. And why is that? First of all, as I said, is because we look at the pursuit of public interest as an abstract reality that we assume as an economic goal, which technology can actually contribute to, basically. And we see it as an instrument of efficiency. But the pursuit of public interest takes shape through materialities, through procedures, through asymmetric relations. And we should not forget the public in public interest. And this is something that I think is important to understand. So in this pitch, I would like to offer you 3 thoughts, building one towards the other. And the first one is on how digitalization is turning the experience of engaging with governments into a dematerialized, lonely operation without interlocutors, where the public interest is only mentioned in abstract, but it's not really realized in practice. The second aspect is on basically how all this pursuit is leading to a greater number of vulnerabilities, but at the same time, the vulnerability frameworks we have established in all these acts, in the GDPR, in the DSA Act, are frameworks that are not equipped to actually address the harms that follow. And the third element that I'd like to mention is that, what does this all mean for the pursuit of public interest? How is the digital shaping our public values? Do we actually need to think about new public values in this context? And basically, I'd like to try to reflect on these 3 elements. So let me begin with the first element of the experience of administrative law, because I don't think we can have a serious conversation on the public interest in the digital rulebook without actually first asking what the digital is doing to the citizen-state encounter, because basically the citizen-state encounter has all been shaped with safeguards that worked when we had, a traditional encounter, which was based on the idea of the file. So the Weber idea of the file. You have a file, you have a dossier, acta, you have something that is an administrative record that is physical, that is thought to be something you can consult, you can contribute to with documents. But basically, this idea of the bureaucratic office, the file, the Kafkan idea of paperwork, is something that constituted our modern statehood. And but basically, it's something that is kind of like changing in a way that we haven't really like transported into law. So basically, the written form that we actually built is a written form that has changed and it has reshaped every single interaction that we have, but also how we have protected these interactions. And basically, every single safeguard that we have, and these are safeguards that are essential to protect the public interest, are safeguards that follow from this idea that you have a file, you have somebody that you give the file to, something you interact with, and somebody has to hear you, someone that you talk to, and somebody has to explain to you reasons about why their file is being built the way it is. But nowadays, this object does not exist in the same way. We have now a dematerialization of the object of administrative law, but we have a fragmentation of information. We have database inquiries, we have records that are assembled at a moment of queries, we have data flows. And basically we have outputs that actually are so fragmented that we no longer have a file. But we also have other elements, which is that now in administrative decision making, what you see is that it's incredibly difficult to pursue the public interest in the same way, because basically when a decision is made and is shaped by technological elements, it is actually very difficult for citizens to really contribute to it meaningfully when everything has been shaped in such a way that is actually like that the civil servant already assumes that it's already correct, it's already complete. There is this like illusion of completion that has to do with the fact that public administration has become, kind of like, in a way, almost like objective or like the use of technology gives it an illusion of objectiveness and completeness of information because there is just more information available on the side of the citizen, but also on the side in general of society. But at the same time, the problem is that administrative procedure presumes an interaction. It does not, it presumes that there is a request, a response, and it presumes that there is like a dialogue between the different parties. But now what we see in digital administrative states is that we don't have interaction anymore. We have one-sided interactions. We have the citizen that is alone, and they have to fill in all the forms. And all the work, all the legal labor is basically shifted to the citizen. The citizen just finds itself before a computer, before a platform, and the citizen has to actually upload all the information and contribute to the file almost in a one-sided way. And when it works very well. But it probably works for everybody here in this room because we are all literate and we all have the skills and knowledge, probably are lawyers, so we know how to engage with it. But the problem is for 30% of the population, it does not work. So this 30% of the population actually finds themselves finding, in a position of vulnerability because they actually don't know how to engage with, the rules. They don't know how to interact, and there is nobody really helping them to basically interpret the information. And this takes me to the second point, which is vulnerability. So basically, if 30% of the population is having troubles engaging with digital government, engaging with digital public services because they are left alone, basically trying to make sense of how digital government has become and what their rights are, we should think, well, are these 30% of the population protected by vulnerability structures and laws? And actually, when you look at the law itself, the answer is no, they are not, because the EU law is traditionally very much focused on the so-called particular approach to vulnerability, which is there are groups that deserve vulnerability, that deserve the vulnerability protection. It's an exceptional protection that is given, and you find it in the GDPR. You find it in every single framework, from consumer law to basically the AI Act. There are people that are seen as vulnerable, and these people are protected in different ways. And all the laws are basically they acquire this idea of protection based on exception. And of course, there have been interpretations of this. My colleague and co-author Gianclaudio Malgeri, who is one of these rooms here close by, he has written a lot about the protection of data protection subjects that are vulnerable. But the issue is that when you only take vulnerability as something that pertains to a certain group, this means you actually forget about structural vulnerability. There are people who are placed by definition in a position of structural vulnerability. These are not protected because, only systemic problems are addressed, but systemic problems are different from the structural problems. And secondly, there is the issue of basically that we have people that find themselves in vulnerable situations because basically interacting with governments puts you in a position of power symmetry. you only have one provider of a service, you're dependent on that provider, there is a monopoly here. There's a monopoly of, decision-making and public services. You have nowhere to go. You're not a consumer. And this is, an issue because it means that you are placed in a position of dependency vis-a-vis the governments. And this actually means that this dependency, this vulnerability is situational. You're not dependent, you're not vulnerable like when you go outside on the street and do something. You're not like a child. But at the same time, you don't have any protection. And this is a problem that we see, that all the legislation that we have so far has not actually considered these elements of situational vulnerability, relational vulnerability, and structural vulnerability that people encounter a lot when they interact with government. And they encounter even more now with digitalization because they are alone in their contact with government. There is actually no more the civil servant behind the counter that can help them mediate and interpret the law. They just basically on their own, because there has been a reshifting of the labor and responsibility from basically the state that would help to basically the citizen. So this brings me to my last point, but also the starting points of my presentation, which is basically the public interest. Because when we actually consider these elements, the fact that we have different kinds of vulnerabilities that are created by the law, by the systems, by administrative procedures, but we also have an exacerbation of different vulnerabilities, the public interest becomes important because the public interest, should take this into account. The public interest is a relative term. It changes with time. The public interest from 100 years ago is not the public interest now. And nowadays, if we think of the public interest and trying to contribute to the discussion that Ludovica introduced, I think is a public interest that it should be bound up with responsible innovation, not just innovation, but responsible innovation, with the pursuit of digital sovereignty, with the protection of public values like privacy, equality, sustainability, human dignity. And these are the values that should infuse our pursuit of the public interest, but also the protection of vulnerability as a relational and situational element. Does this mean that public interest should mean the same thing across the whole digital rulebook? Well, no, because each instrument, of course, seeks to protect different elements. And each instrument has a different function. So the GDPR is more procedural, it's more authorizing. The DSA is more substantive. The AI Act is focused on risk management, mostly. But the problem is that even though these different acts should not necessarily have the same idea of public interest, but it is important to actually think about the values that are underneath it. And it's also important to think about the element that underneath all this continental and common good tradition of the public interest, we see actually a bit of like a tension between two elements. So we have the element of public interest connected to fundamental rights, which we see a little bit in the AI Act, but we also see the procedure of public interest connected to procedure, which we see in the GDPR, for example. You have to have consent, you have to apply for certain steps. So we have a bit of like the two elements. You have the procedural idea of like you pursue the public interest if you fulfill certain steps, but you also have the other element that you pursue the public interest if you are protecting fundamental rights. And I think it's important to see this dichotomy because when you look at the charter, you will see that it's not only about procedure, it's also about fundamental rights pursuits. And while administrative law is a field of law that focuses mostly on procedure, I always tell my students, in administrative law, the end goal does not matter that much. What matters is that you follow the procedure. It's very disappointing, but it's true. Following procedure counts. Because we, in administrative law, think about, bureaucracy. And I think in the digital, especially when you have citizens that are alone, I think this is something that we should actually change a little bit. We should reinterpret it. And this brings me to my last point, that basically the digital is reshaping not only public values, but it's asking to think about new ones. Because if we want to actually interpret the public interest in the digital at a time when citizens are alone, facing digital governments by themselves without any kind of help, I think it's important to think of new public values like intelligibility of administrative action, reachability of the state, human contact of the state, but also maybe the right to an interlocutor, not being just alone trying to figure out everything by yourself, not being governed by interfaces that actually don't really improve, administration. Because ultimately, a right to good administration, a right to pursuit of the real public interest should mean that you should not be left alone with complex forms. You should not be, you should not be left with large amounts of data that are completely fragmented. And mostly, it should be that it should mean that you actually have the right to really be heard. To summarize, in my opinion, coming from administrative law and the study of the digital administrative state, I would say that the public interest in Europe's digital rulebook will only be meaningful if we are willing to update what counts as a public value. So not just only thinking about privacy and sustainability. These are very important public values, but we also need to think about more specific interactions. Think about public values in the relationship between government and citizen in this case, and also replace our group-based vulnerability frameworks with more relational and structural ones that actually take seriously what the digital state is doing to citizens and also what it claims to serve. Otherwise, if we only see the public interest as something rhetorical and abstract, it's an empty goal, and it's an empty goal that will be basically captured by the economic logic of the markets. Thank you.
Thank you very much, Sophia. Thank you very much. You raised a very interesting point. I was quite interested in your when you highlighted the relevance to have individuals as real interlocutor to cite the literature on that topic. So to have a meaningful interaction with the governments. And you also mentioned a sort of the fact that the public sector right now depends on private actors in order to achieve some public interest, at least. So that's the reason why I'd like to turn now to Theodora Groza. Theodora is a postdoctoral researcher at the University of Tübingen and Sciences Po, and she works on data markets and the role of regulation in promoting innovation, in dealing with innovation. So considering the current EU digital rulebook and the fact that public interest is very frequently invoked as a sort of bridge between regulatory objectives and economic governance to some extent, it also becomes clear the fact that public interest is entangled with the protection of fundamental rights, the safeguards of fundamental rights. So I'd like to know, in light of your work, about the shift from a privacy-centered approach, fundamental rights approach, to a more market-integrated regulatory framework, if you think that this risk approach, particularly related to the Act, for example, is capable of concretely, genuinely aligning market efficiency, innovation with public interest, with collectivity values to some extent. The floor is yours. Thank you.
Thank you so much. Can you hear me okay? Perfect. Thank you, Ludovica, for the introduction and for setting the scene. I have to begin by telling you that Sophia actually said a lie. She said many true things, but one of them was a lie. When she said that admin law is the most boring class, it's not true. I was her student. It was my favorite course of the semester. Which means that I'm very well prepared to speak about the public interest, having had her as my mentor early on. Now, let's switch the substantive part of my discussion. So, when we think about the public interest, what comes to mind are usually ideas such as welfare, taxation, redistribution, social safety, public services, institutions, environmental protection, and so on. What's interesting to see is that even though there isn't any specified notion of what the public interest is in the digital rulebook, we can connect the dots and identify a common thread. And in my opinion, this common thread pertains to the fact that all these instruments, one by one, put forward a new idea of the public interest, which means having access to markets that foster innovation. And I think that we see this shift gradually from the GDPR, when the focus was on privacy and data protection as a value of fundamental constitutional importance, whereas since the data strategy, which came out in 2020, the goal is, and I quote, to help society get the most out of innovation and competition. At the first sight, this shift seems to give rise to a clash. The EU used to care about rights, now it cares about markets. How is that coherent? But actually, what is at stake is something which is much more subtle, because markets are not presented as an alternative to rights and the public interest, but actually as arenas where the public interest can be achieved. And to give you some examples, you can see that in the data strategy, innovation and competition are not put forward as end goals, as what we care about, but rather as instruments which can be used to achieve objectives such as personalized medicine, new mobility, sustainability, energy efficiency, and so on. And you can see the same approach, for instance, in the AI Act, where you have the narrative that we need to boost innovation and to increase AI uptake, but not because AI is an end goal, but rather because AI can lead to socially and environmentally beneficial outcomes in healthcare, agriculture, and so on. What's interesting, and this is what I'm going to unpack in the following minutes, is that the EU doesn't try to achieve directly its objectives. It doesn't put forward mechanisms which directly tackle mobility, healthcare, sustainability, and so on, but rather it tries to enlist markets, market actors, undertakings, consumers, and even public authorities in this process of steering innovation and competition towards the public interest. So let's see how that works, and also what are the trade-offs, because there's always something which gets lost when we choose a certain approach. How does this work out in practice? So I'm gonna walk you through 3 different acts. First of all, the 2 pillars of the data strategy, which are the Data Act and the Data Governance Act, and then the sexy topic of the last year, the AI Act, of course. So the Data Act is an act which is very strange because it has a very, very narrow scope, but it has a very, very ambitious institutional architecture. Its focus is specifically on data which is generated by smart devices, like for instance, connected fridges, vacuum cleaners, not very interesting. But what's interesting is that it puts forward this vision of users of these devices as key actors in the data economy. And this mechanism is made visible by the fact that these users are given the right to ask that the data they produce is used in their own benefit. And the way in which the EU understands how users can benefit from data is to giving them access to more competitive and innovative markets for so-called aftermarket services. So the idea is that if you have a vacuum cleaner and you want to repair it, you won't be obliged to go back to the manufacturer, but because you can access all the data your vacuum cleaner generated, you can go to another provider, give them the data, and ask them to repair it, ideally at a lower price. So you see here how, first of all, the EU asks consumers to participate in this public interest through markets mechanism. But you also see that the way in which the EU understands the public interest is very innovation-centered. So the idea is that users are happy when they have access to better, more services. Now, if we turn to the Data Governance Act, we see actually a very similar dynamic. The Data Governance Act is less weird as an instrument because it's broad both in terms of ambition and in terms of scope. What it aims to do is to create a so-called trusted framework for data sharing. What's interesting about the Act is that it's not only market-focused, it also seeks to give rise to so-called alternative data sharing mechanisms, like for instance, data altruism, and we have an expert here on the panel. But we have the same approach where the EU truly believes that the way to have concrete benefits in health, mobility, agriculture, and so on is to create a data economy where more users and more businesses can access this data. So the same idea. And now, when it comes to the AI Act, even though there's this idea that the EU only cares about fundamental rights and the AI Act is overburdening and it kills innovation, actually the AI Act is very innovation focused. And if you read through the recitals, it's obvious that it refers to AI as a provider of key advantages to undertakings, but also as a vector for achieving socially and environmentally beneficial outcomes. What's interesting is that even though everybody says that the Act is fundamental rights focused, it's obvious that the Act actually seeks to promote the adoption, development, and deployment of AI. And this is visible also in the way in which the Act goes forward. Very few practices are prohibited, and the Act doesn't seek to prohibit or limit AI. On the contrary, it tries to create legal certainty so that AI development and deployment is actually encouraged. And what's interesting is that the Act goes one step forward by actually enlisting public authorities in the innovation ecosystem by asking them to create the so-called sandboxes for AI development. What I find interesting about the AI Act is the fact that it's often portrayed as being retrograde and going back to the sole focus on rights and so on. But actually, it's not the case at all. And there's recent scholarship saying that the focus on fundamental rights is only a halo, because if you read through the Act and see what it is about, fundamental rights are only very minor, and they give users and citizens very limited mechanisms for redress. Now, I walked you through the acts. Now let's see what actually is at stake here. These acts often read as if they were given by some sort of God that holds immutable truths, and that's the way it should be. But actually, what happened in the acts is that they put forward a public interest narrative which has to be questioned and which doesn't necessarily overlap with what EU citizens like you or me understand the public interest to be. And I really wonder whether people like you and me would actually think that creating new markets, having access to new goods and services, and having more AI adopted throughout the EU is actually what we care about. What's also interesting is the image of EU citizens that these acts operate with. Because through the Data Governance Act and the Data Act, the vision of citizens is that of tech-savvy individuals who care about sharing their data and who care about more innovation. And the same in the AI Act. We are really portrayed as people who want more AI because we think that AI is the way to have a better society. Now, is that the truth? I'm not sure. What's interesting is that this vision of the public interest was not developed through any sort of democratic consultation or surveys or anything, but it was rather the product of the geopolitical innovation gap with China and the US, and also with the recent focus on digital sovereignty. So what happened was that because the EU perceived its sort of backlog in terms of catching up with innovation on other continents, it just thought that regulation could be instrumentalized as a way to have more innovation, while still framing this innovation focus as a public interest objective. Now, a couple of concluding thoughts. What I find interesting is that these acts don't just focus on innovation, but they really lock in innovation as the one goal we should be focused about. And this is a thoroughly political choice, even though it's portrayed as being very obvious and very self-evident. Now, the question that's often raised in scholarship and in public debates is whether the acts will actually work. So will we have more innovation? Will the AI Act slow down? Will the Data Act give rise to more services? Will the DGA give rise to more data markets? But I don't think that's the question. I think the question is whether the vision of the public interest that these acts put forward is the one that we really care about. And something we should also think about is what gets lost when we focus on this narrow understanding of what the public cares about. Because putting forward this vision of markets as the arena through which the public interest gets instrumentalized also forecloses other options. Why do we want to create data markets rather than put in place public data infrastructure? Why do we want to regulate the risk of AI systems rather than create our own AI companies, which are governed maybe through public-private partnerships, for instance? Also, why do we want innovation? Maybe we want less innovation. Maybe we want more environmental protection and less usage of AI that is actually very energy consuming, uses a lot of electricity, water, and so on. And also something that we should focus on is, where is our voice? Why weren't we consulted when this digital rulebook came out and asked, what do we care about when it comes to the regulation of digital services? And ultimately, the final question, I think that's the hardest to answer, is why would the EU invest resources in AI sandboxes and creating data markets and fostering data sharing rather than tackling the objectives that are ultimately pursued directly? Why doesn't the money go straight to public mobility or personalized medicine or agriculture and so on? It's a big question, but I'm just going to leave you on that note. And I look forward to the Q&A. Thank you.
Thank you very much, Theodora. a lot of interesting observations. You mentioned at the end of your speech the role of participation in the definition of the policies, in the definition of digital policies, and I believe this is quite relevant considering the interpretation of the public interest strictly related to the role of collectivity. So basically, you just have outlined, you just captures very well how across the EU digital rulebook, public interest, market logics, and fundamental rights safeguards are combined, but with a lot of open issues and with a sort of significant tension at the basis. And in this regard, I'd like to invite Véronique Simina to intervene. She's a case handler and legal officer in the Digital Services Unit of Risk Management and User Rights of the DG for Communication, Networks, Content and Technology at the European Commission, where she contributes to the supervision, enforcement and monitoring of the DSA. Thank you very much also for, because of your busy schedule, so we are very happy you're here today. So it's precisely about the notion of public interest within the DSA, within the legal framework provided with the DSA that I'd like to hear your thoughts about. Since within the DSA, the notion of public interest is strictly related to the sector of scientific research, and that's similar to the GDPR approach to some extent. So I'm referring in particular to Article 40 of the DSA and Recital 97, and so that's more or less what I'd like to have your comments on. So the floor is yours. Thank you.
Thank you. I hope, can you hear me? Yeah, perfect. So hi everyone, and nice to be here in this extremely interesting panel. So I think what I would like to focus on is indeed the objective of public interest manifested in the research possibilities. So because of course, as you may know, open science research is and has been a priority for the EU over the past years, with the aim indeed of advancing knowledge through data sharing, transparency and collaboration. The notion of research, we start from, let's say, the GDPR angle, where scientific research was given also a privileged position within the GDPR framework to have, let's say, a more flexible regime, but also a more rigorous framework in order to balance innovation, research, and fundamental rights. So the key tension in the GDPR has always been indeed how do we reconcile data-driven research, so thriving on openness, with data protection, so the prioritization of individual rights. So the line and the interpretation of research within the GDPR has always been the GDPR does not necessarily hamper innovation, because I think that was indeed one of the key criticisms, that indeed the GDPR was sort of a bit of an obstacle to performing research, especially for the objective of public interest, which we have all agreed indeed that it is not defined, right? So that makes it even more complex as to how to identify what is public research and public interest, and so of course how does this fit within the bigger research framework. So the objective indeed, the GDPR does not hamper research, but encourages responsible data-driven innovation. As we also heard, innovation is key for the EU legislator, but also gave this kind of flexibility. The specific regime, if you're researchers, you may be used to applying Article 89 GDPR. So the use of public interest as a possible use for a derogation. And indeed, the issues that have been identified also under the GDPR is the fragmentation at member state level. So if you have, let's say, a member state project, how do you use and how do you reconcile the different legal bases that are necessary at national level. So in my previous life, I was working at the DPS, and of course, this was one of the main criticism that we heard. How do we reconcile if in one member state, we need to use consent as a legal basis for research, in other member states we can use public interest? So how do we do that? So the different legal uncertainty has been indeed has been something that has been also at the core also of the discussions and also of the work. For example, if you think about the work of the European Data Protection Board, when it interpreted a bit the use also of the various legal bases, and also encouraged indeed, given this cross-border fragmentation, they also encouraged the use of public interest and legitimate interest as a better legal basis rather than consent, right? Which is also probably a bit of a dichotomy. Consent always has this effect, as a dichotomy of research versus the achievement of the public objective, so public interest. Then, indeed, the colleague has touched already also on the DGA, on the Data Act, on the importance somehow that legislation has given to the concept of public interest. I can also think, indeed, also of the European health data space, and there how evident it is that, let's say, the use, for example, of health data for secondary research is really made manifest and big part indeed of the regulation. And so the objective there is really visible in terms of, okay, our health data can be used and should be used also to foster, let's say, research, secondary use, innovation, also in the context of, also in the light of episodes such as the pandemic, which has brought indeed so much uncertainty also in terms of realization that we didn't have enough data, that we didn't have enough ways to share data and use this for research. So this being said, in this context, just like, let's say, the medical research community has harnessed indeed the power of medical data also for mutual benefit of patients, this is also what is applied in the context of the DSA, in the context of Article 40, which is a provision that I work on daily, and that is very important to us and to the Commission in general. Just like the same way the research community has harnessed the power of medical data, the social media research community can now, also through the DSA, harness the power of social media to improve our understanding of our lives online on a daily basis. So just briefly, I think it's important, especially if there are researchers in the room, that I think it's important that the objective of the DSA, and in particular Article 40, is not only understood but also made use of, because I think this article is a big opportunity for the research community and for public interest and for the public good to develop throughout the EU. So we know that, for example, very large online platforms and search engines indeed detain a lot of data, a lot of information. They, make our lives easier, but also have a lot of risks. And one, indeed, of the key novelties is related to Article 40. We can think of different questions that we may have in mind, like how do platforms' algorithms deal with dangerous content? How do online scams propagate online? How does online polarization shape discourse? Or what are effective mitigations against online hate and violent threats against women online? So in this context, the DSA gives, for the first time, I would say, a very important possibility, which is indeed the access to the data held by platforms. Now, Article 40 is a realm of its own. It is a very complex article, but it is mainly founded on two principles. So researchers under Article 40 can have access to privately held data by platforms under Article 40.4, but also publicly available data. So data that is publicly accessible on a platform under Article 40.12. So they are two separate processes. Article 40.12 requests under Article 4012, for example, so to publicly accessible data, are already ongoing. Indeed, the Commission has also opened quite a few cases on this provision. Whilst Article 44, so on access to privately held data, so data that is not manifestly made public on the platforms, to this end, the Commission has adopted in July last year a delegated act which creates and puts in place, let's say, the process for qualified researchers, so researchers that fulfill specific criteria, so set out in this delegated act, well, set out in the DSA, but indeed enhanced by this delegated act, to have the possibility to access such information in order to carry out research on systemic risks in the EU. For example, what is in the scope would be like dissemination of illegal content, negative effects on fundamental rights, or negative effects on civil discourse, electoral processes, and public security, as well as gender-based violence, protection of public health and minors, and serious consequences to physical and mental well-being. So in this case, I think it's very important to note that the platforms very often indeed have blind spots, when it comes to risks on their services, and indeed research and what is let's say proposed and tried to be enhanced by Article 40 is indeed like underlining that research is indeed vital for regulators, but mostly for researchers. So this is, I think, one of the biggest, one of the most important provisions of the DSA, not only for the opportunity that it gives, but also for the value and contribution that research has on the identification, of what is indeed public interest. I think, the previous panelists were very right in saying, okay, we don't have a definition. Are we sure that we all mean the same thing? Well, in this context, the DSA, I think, helps in ensuring that researchers can actively contribute to this by indeed doing research on these aspects. So I think I would be very happy to answer questions in case there are any, but I would like to leave you with this message that I think the conditions that the DSA and Article 40 specifically in the context of research imposes are meant to balance indeed the right to research and the fostering of public good, but also still keeping in mind the need to protect fundamental rights such as privacy, security, and confidentiality, both on the side of users whose data would be processed, for example, by a researcher in the context of research, but also, of course, keeping in mind the interests of the platform. So the goal, the objective is indeed to, as the GDPR is not indeed was not meant to be a barrier to open science and innovation and research. The same goes for the DSA, which tries to indeed enhance this right by ensuring that there is some sort of common understanding and common research values. So I think I would not necessarily go into the whole process, but if anyone is interested, I would be very happy to answer any questions. Thank you.
Thank you very much, Veronique, also for your giving us a perspective about opportunities related to the EU digital rulebook. We are very often very critical, so there are also some aspects not without any issues, I would say. You mentioned fragmentation. There are others, maybe during the debates, some more aspects will be analyzed. You mentioned fragmentation, you mentioned the DGA, Theodora as well before, from a theoretical point of view. For example, within the Data Governance Act, we do not have an explicit reference to public interest. We have a reference to the general interest, and the EU legislator says general interest is what member states says general interest is. So that's something that was related to the fragmentation you were mentioning before. But your contribution also opens up, let's say, a broader reflection about the evolving nature of the EU digital rulebook, especially in light of the ongoing initiatives such as the digital omnibus or the omnibus packages discussed and adopted by European institutions, with the goal to further reshape, let's say, the balance between regulatory coherence, flexibility, and fundamental rights safeguards, I would say. In light of these evolving European digital rulebook, I'm pleased to introduce our final speaker, Laura Caroli, policy expert and civil society ambassador at Women in AI Belgium, an independent expert on AI governance working at the intersection between AI and public policy. So in light of these evolving legal framework, how do you see the notion of public interest being reframed within these rapidly changing legal infrastructures, legal architecture, that we can say that increasingly responds to market rationals, to mention again Theodora's speech. So that's the question for you. The floor is yours.
Thank you, Ludovica, and thank you so much for inviting me to speak on this panel today. Yes, I had in my previous life the opportunity to negotiate directly the AI Act, and so I've seen its evolution throughout the process until what it is now after the AI Omnibus. So as has been mentioned, the AI Act also is about this tension, about conflicting interests, public interest versus private interest at first, and also within the public interest there are conflicting elements per se. First of all, I would like to respond to Theodora by saying that the AI Act needs to be seen not in isolation, but it is complementary. It is an additional layer to GDPR, consumer law, and the rest of the digital acquis. So we cannot. I don't think it's right to address its limitations just by looking at it in isolation, but as a part of the overall system, also when it comes to fundamental rights. Funnily enough, the public interest is mentioned several times, especially in the recitals of the AI Act. And public interest is always related to the concept of health, safety, and fundamental rights. So first of all, the structure of the AI Act itself is product safety legislation, which acts on the design itself of the product, in this case, an AI system, in order for it to be safe. Of course, this makes it complementary to GDPR in that GDPR frames the overall protections on when it comes to automated decision making, in particular in the EU. But it's mostly about internal governance of companies and access and rights of citizens, whereas the AI Act acts directly on how the product is designed in the first place, even before it reaches the market. And that's why I believe these two in particular must be seen together. First of all, the two objectives of health and safety are the usual product safety public interests for all products that are regulated in the EU, from toys to lifts to medical devices, etc. The AI Act introduces a fundamental shift, which is the addition of fundamental rights that is not present in other product safety legislation, and creates an additional layer of complexity because fundamental rights cannot be measured pre-market in their fulfillment and only can be assessed ex post. This generates a lot of tensions also in the standardization process that is ongoing on the AI Act operationalization. The second element that I wanted to introduce is that the AI Act speaks about public interest, in particular in one article, that is the possibility to further process personal data within a sandbox environment. Companies can, if they are in a sandbox environment, reuse personal data that they collected for other purposes in specific cases of public interest, of substantial public interest that are listed in the AI Act, and they are, for example, public health, as you just mentioned, is always generally considered a substantial public interest to protect. The environment, sustainability, energy sustainability, efficiency of public services. So in these cases, the public interest is considered trumping the protections that, the limitations that are introduced by GDPR in allowing this further processing. Third element that I wanted to introduce is also how, first of all, the evolution of the AI Act shows also how this tension between the market element and the fundamental rights elements have also evolved since the first draft to where we are now in several ways. First, you both mentioned, for example, the prohibitions that were limited in scope, and the higher emphasis on innovation and market uptake of AI, promotion of an AI sector in Europe, which is, of course, one of the objectives of the AI Act. When it comes to, sorry, I lost my train of thought. Okay, I will come to this later. Let me introduce another element that is present also. It's important in the context of the AI Omnibus. Further evolution. We are here now. The AI Act has just undergone a whole AI Omnibus procedure that just ended a few weeks, 2 weeks ago, and that was supposed to be an effort in simplifying and streamlining procedures in the AI Act. Just at a moment when the AI Act didn't fully apply yet, there has been some criticism about this exercise that serves an imperative, indeed, to further stimulate the private interest, market, industry uptake of AI, and competitiveness. Competitiveness is now a trumping public interest, private/public, because the public has embraced it as the key industrial goal. Industrial policy goal of this period, with the new majority, the new commission, the new parliament, etc. So in this regard, there's one article, one provision that I want to talk about that has seen a shift, not necessarily because of a market versus private fundamental rights dichotomy, but rather it can also be seen because of a conflicting fundamental rights per se. So I'm talking about the possibility to process sensitive personal data for bias detection and correction, which is considered a matter of substantial public interest allowed under GDPR, Article 9.2, paragraph G. So this is considered by the AI Act a substantial public interest, the fact of detecting and correcting bias, which is one of the unfortunate byproducts of AI that we know of, that needs to be limited. And in this regard, the conflicting interests are the protection of personal data and the right to non-discrimination. These are two conflicting fundamental rights that, and the resulting balance has shifted. This is what I want to talk about today and show you from a balance in which that you see in the now in force AI Act and the result of the AI Omnibus. In the AI Act, now the possibility to process sensitive personal data for bias detection and correction is very limited. It may happen only when strictly necessary, and in addition to the safeguards already provided by GDPR, subject to further conditions and safeguards. Now, with the AI Omnibus, the problem of bias detection and correction has been judged more important, slightly more important than before, compared to the AI Act that exists already. And so now this possibility has been extended to all AI systems, not only high-risk AI systems, and also to providers of all AI systems. Before, it was only permitted to providers of high-risk AI systems. Now it's possible for all providers and all deployers of all AI systems, subject to the same safeguards. Now, it can be interpreted as giving the rights to private companies to harvest more sensitive personal data and process more sensitive personal data under this justification. But it can also be argued that it is actually the issue of two conflicting fundamental rights, and in this, the balance between the two has shifted a bit towards the protection of the right to non-discrimination. To be honest, I can even explain an anecdote on this. At first, when the Commission first proposed the text, the safeguards were not listed and were not as substantial as they are now in the final text. There was just a reference to GDPR, basically to what is already foreseen by GDPR. And there was a majority at the time in Parliament to delete this whole possibility altogether, because it was considered a loophole in the protections offered by GDPR. In the end, there was at some point, what shifted this negotiation was a report by the Fundamental Rights Agency that highlighted how when you don't know that a bias exists, because you don't know the possibility to discriminate in a data set, etc., you cannot detect the bias, and so the AI system cannot detect, and therefore no one can mitigate this bias. So it was told to the negotiators, maybe you should consider the possibility to have a limited possibility to process sensitive personal data, and that's exactly what happened, while remaining proportionate and targeted. Now it is, of course, broadened, because even non-high-risk AI systems can be discriminatory. We will see how this will apply in practice. And I want just to conclude by saying one thing, that, of course, the final result of the AI Omnibus has seen a clash of two interests that are not actually conflicting, but that became very prominent in the AI Omnibus negotiations and that are now enshrined in the final text. One is the right to human dignity, and that resulted in a new ban on nudifier apps. I'm as an ambassador for Women in AI Belgium, I feel I have to mention this element, which is a big novelty in the AI Act. So an additional ban that was mostly uncontroversial, because it was even the member states all agreed that this was a necessity to limit the possibility to generate deepfakes of nudified deepfakes of women. And at the same time, the business industry interests also were particularly vocal in trying to reshape the final result of the AI Act. So again, market very prominent in the discourse, and that resulted in excluding the machinery sector, the industrial AI, as they say, even though I would say that the final result, to me, if you really look at the details, is even more complex than it was before instead of simplified. But anyways, so.
Thank you very much, Laura. So thank you very much to all of our speakers. I don't know if Theodora wants to reply, or maybe we can collect some. Okay, so now it's time for your questions. So we're going to open the floor to your questions and comments. There's a hands there. I'm going to give you the microphone.
Hello, I'm Vilma from the University of Amsterdam. Thank you very much for the presentations. And my question is directed towards Veronique and Sophia, both of them, I guess. Veronique, you rightfully mentioned that, of course, within the DSA and Article 40, so I'm talking mainly about public interest research, it is a balancing act that we're doing in relation to, of course, the information that research would like to know, and then the private interests of the platforms, so also to protect businesses. But it seems that lately, also even with the existence of Article 40 of the DSA, this balancing act is tipping more towards private interest rather than the public interest part. And as an example, we have the fact that a lot of platforms, they even with Article 40 of the DSA, they refuse access to data. So for example, I'm talking about the X case. And then just a week ago, even if then civil societies want to avail themselves of those procedural structures that Sophia was talking about. So for example, the right to access information, then they get barred by the commission, always stating, for example, this is confidential information, it's business information. And so my question is, with the current state of how things are, should we maybe perhaps rethink this balancing exercise, also keeping in mind these structural vulnerabilities that Sophia was talking about? Thank you.
Maybe we can collect another question. There was a question there.
Thank you. It's a question for you, Sophia, more generally for the panel. First of all, thank you for highlighting the impact of digitization on public service, the examples you gave with, the concept of file, the civil servant you could talk to. You discussed across the panel the tension between different interests and how is that reflected and prioritized at the level of the law. But there is another layer where prioritization happens, which is economic decision, where municipalities, public services decide to prioritize resources for somebody people can talk to, or if you take a data protection authority, where some of them have been quite explicit that they will focus on the big thing, and if a data subject has a small thing, it's not going to be prioritized. So I just would like to, maybe it's an unfair question because it's economic, but I just want to say there is also the economic layer of how the law is applied and how resources are prioritized, and would love to have your perspective on that.
Collect the third one, and then
I have a question for Laura. So you mentioned that the competitiveness is the new public interest, but it could also be private interest. So I would like to know what are your thoughts on this. It's a completely open question, of course.
who wants to start? Sure.
So Well, thank you for your question. It appears that you're very up to date with all of our work on this. So, I think so. In terms of, I think first I would like to start with the idea that the provision itself. So the provision itself is quite clear in terms of. So I assume you are referring more to access to data, to access to publicly available data, right? So I think you're referring more to the angle of researching through having access to APIs, etc. So here, just on this angle, indeed, the Commission has been extremely active also in our supervision and enforcement role. I think I would start by saying that the provision is indeed very clear in saying that the objective, first of all, starting from the objective, which is solely the usage of data solely for the purpose of performing research that contributes to the detection, identification, and understanding of systemic risks in the Union. So I think this is, to be honest, this kind of brings me a bit to the answer. I think on our side, this is very clear also when assessing the provision. It is also very clear that the conditions, for example, for having access to this research, to this data, are indeed that the researcher needs to fulfill specific criteria. There is no affiliation requirement when there is access to publicly available data, so the independent research is also fostered in that sense. So this I would like to echo that under 4012, under Article 40.12, independent researchers are given quite an important role in accessing data for the public good. Then in terms of ongoing enforcement actions, as I mentioned earlier, we have currently we had 6 formal proceedings that were opened in relation to Article 4012, against X, TikTok, AliExpress, Facebook, Instagram, and Temu, including indeed the grievances on Article 40.12. I'm saying this just to highlight the fact that at least for the Commission, compliance with this provision is important, and providing access to data, whether it is public through by means of Article 4012 or to privately held data by means of 44, is essential to us. So I think my gut reply would be maybe it's a bit too early to still to check, well, to revise the text. But what is important is that what I would like to underline is that we are indeed following this, and that I think with the cooperation and help also of the research community in flagging these aspects to us by means of wider research outreach, but also individually. I think this helps also for our enforcement work, which is a priority specifically on this provision. So I hope this partially answers.
Thank you, Veronique. Sorry, we have not a lot of time, so I was just to add about public availability of data for research purposes. We have also to take into account another legal framework, which is the Open Data Directive, which dedicates an entire article for research data, and it mandates that there is a mandate for member states to intervene. So there's also this layer of complexity. Just to move on with the questioner for Sophia.
I do this one. So both great questions. So regarding actually your question, so I think there's something that we should distinguish, and all these acts, PSI, open data, all this pieces of legislation, they address an actor that I wasn't addressing in my pitch, because basically they address a professional actor. Usually they address the researcher that wants to have access to data that has much higher literacy, that has much more support, and this is the difference, right? Because if you see in European law, there's a big distinction between for example, in state aid and all the financial economic law part, it's always the standard of the market actor is a much higher standard of the person who can comply with all these requirements and who can be left alone, because this is a person that wants something from the Commission, and because you want something from the Commission, you are equipped to actually do it. Then all this story of vulnerabilities changes a little bit, because even though you're still in a relational an asymmetric relationship, you're not as asymmetric as the individual that is applying for social welfare, benefits. So this is a big difference, I would say. On the economic law approach, yes, this is completely true. There are political choices, there are economic choices that are made when it comes to legal application. And what is interesting is that we see this a lot, for example, also in tax law, where, like tax authorities in the Netherlands, they have decided not to pursue fraud in small scale right now. They want big scale fraud. So, because, which has gone wrong as well, I must say, because it has also been very biased. But it is a decision, of course, to actually prioritize the bigger issues. Even the ombudsman actually now only has time to prioritize bigger issues. But what we also see is in the digitalization of government is that actually the economic argument hasn't been empirically supported because some of these new uses of digitalization, they don't always lead to savings. They sometimes do lead to savings, but not always. And this is when, if you want to really go like full on economics, it's fine, but because it's a political choice, in times of crisis, we have to think about savings, obviously. But there is also like a very big trade-off. Yesterday I was talking to God about this. Sometimes the trade-offs are forgotten, and not only trade-offs in terms of like fundamental rights, but there are trade-offs that actually we see it later, like in other economic aspects of life. So I think the economic arguments can be justified in many areas, but there is a lot of like empirical gaps on whether it's always worth it.
And I think there's also an issue of adverse selection when public authority says we're going to focus on the big thing. It signals that it's an open door for a small thing, which might be small individually, but might be bigger collectively. So I think the issue of saying we're going to focus on the big thing creates an opening for the small thing collectively to expand. It's a complex thing.
Just to give the last reply for the last question to Laura.
First I wanted to react also to what Sofia just said. Indeed, the AI Act, for example, is about economic operators because that's what product safety law normally talks about. So providers, importers, deployers, etc., are all economic operators. But in this evolution that I was mentioning when I lost my train of thought, and I'm sorry, the citizen also gained much more space in the AI Act because indeed the AI Act also tackles several imbalances of power between the citizen and the state, but also the citizen and the company in several ways when it comes to workers' rights, for example, in the case of companies, but when it comes to the limitations to law enforcement about this relationship between citizen and state. And as for Peter's question, I think that right now, given that AI is a dual-use technology, there is the whole geopolitical context that has been mentioned already during this conversation. This private interest has been embraced by the public as well as a public interest that competes with the others. That's what I would say.
Thank you. We are running out of time. So thank you very much for the questions and for all the speakers and your time and insights. Thank you. Thank you.